and Tech Hive Advisory. I can see some of our panelists. Oh, introductions. My name is Dolapo Adegroyi, and I'm going to be the moderator for today's session. And I can see some of our panelists have joined in, so I'm just going to hand over the mic to them to take introductions. Marisela, please, do you want to, do us the honors of starting? Just introduce yourself and tell us what you do.
All right, thank you very much, Dolapo. Hi, everybody. My name is Marisela Alaba. I'm a legal practitioner in Nigeria. I've also worked on a number of cases and issues around freedom of expression, access to information, digital rights, and also in terms of advocacy on those issues also. Thank you.
Thank you very much, Marisela. Sumaya, please, you could go next.
Hi, Dolapo. So there are two Sumayas. But I'll just go ahead and do a quick introduction. So I'm Sumaya Omar from Kenya. I'm an advocate of the High Court, and I'm one of the founders at IDH Tech Policy Africa. So we're really happy to have this webinar today and to have everyone on board. I'm going to hand over to Arnold, and he's going to tell us more about ITPA, and he'll take it up from here. So from this point, the other Sumaya is Sumaya Moko and not me.
Sumaya, are you with us? I think that's some network issues. Anna, please, you may go next.
Hi everyone. My name is Arnold Ginga from Kenya.
Arnold, your audio isn't so clear.
Can you hear me now?
Yes, it's much better. Thank you.
Let me see. It's my volume. Yeah, I hope that's fine.
Yes, it is.
Oh, okay. Thank you. Yeah, my name is Arnold Ginga. I'm a practitioner in Kenya under the law firm of Ginga and Company Advocates. I'm a co-founder for IDH Tech Policy Africa, and I'm excited to be here. I'm the head of litigation at ITPA. So we do a lot of tech law litigation, which we'll talk about later on. So I'm excited to be here. Thank you.
Thank you so much, Arnold. Sumaya, are you able to speak now?
Yes, hi guys. My name is Sumaya. I can hear you guys clearly now. My name is Sumaya. I'm from Kenya, and I'm a private sector practitioner. I'm also a litigation fellow at the Center for Strategic Litigation, which is based in Tanzania. And yeah, I'm excited also to take part in this discussion.
Thank you so much to our panelists for doing this with us. And I'm sure the attendees, as well as myself, very excited to learn insights from you all. I'll just hand over to Sumaya Omar now to take us on the introduction for IDH Tech Policy Africa.
Dolapo, actually, I'll do that.
Okay, that's fine.
Yes. Yeah, so generally for IDH Tech Policy Africa, popularly known as ITPA, it's an organization that primarily aims to inform and influence tech policy processes in Africa in general, engage in multidisciplinary research, litigate on tech law, and advise on a diverse range of tech policy issues in Africa and beyond, whenever an opportunity comes. So far in Kenya, we are largely practicing in Kenya. We do a lot of tech law litigation in Kenya. Currently, we've been admitted in 3 tech law cases in Kenya. We are participating as amicus curiae. We're just in to bring in the expertise bit in terms of the issues raised in the field of tech in Kenya and the issues currently alive in court. Currently, by way of introduction, we have around 3 pending court cases. sorry about that. Yeah, currently we have around 3 pending court cases pertaining to tech law issues. The first one being Kituo cha Sheria and another versus Attorney General of the Republic of Kenya and others. And that one has been admitted as amicus. And the key issue in that petition is that the petitioners want access to the internet to be recognized as a fundamental right in Kenya, so that we can have an independent right, enforceable, just the right to access the internet. Then the other second case that we're dealing with currently is called Abraham, Marek, and another versus the Meta platforms and others. So that this is another interesting case law in terms of it seeks to have issues to deal with platform liability and accountability addressed by the courts. We all know that the agrarian war in Ethiopia that occurred a few years back, so that these are some of the issues, whether social media was used to influence or had any role to play in instigating the violence in Ethiopia. Then thirdly and finally, the other case that we're currently dealing with before the High Court of Kenya is the case of Africa Center for Corrective and Preventive Action and others versus Google and others. So that in this case, basically, the challenge is on the use of AI algorithms and the sharing of personal biodata using the Google platforms like Google Play, so that if I search today, I can easily get some of this information about data, your details, your location, and all that, so that the petitioners are challenging the viability and the legality of use of such AI algorithms vis-a-vis the right to privacy and the right to human dignity and all these personal spaces protected. So yeah, that is the general overview for ITPA. We are open to collaborations. We are really excited for having this joint webinar, and so that we'll be examining both Nigeria and Kenya and just look at the legal landscape on tech law litigation. Yeah, so basically that's it. Thank you so much for joining us. I see most of you. We are really excited that you're part of this conversation, and it's something we'll have to take it even a notch beyond even this webinar today. Thank you so much. Back to you, Dolapo.
Thank you so much, Arnold. I'll just go ahead and do the introductions for Ikigai Innovation Initiative. Ikigai is a not-profit organization founded with the aim to promulgate research on technology policy and legal frameworks in Africa. We also engage relevant stakeholders around the intersection of law, business, and technology, as well as advocate for better policies towards the betterment of the ecosystem at large. Our researchers work closely with government, relevant stakeholders, ecosystem players, with the aim of promoting digital rights and digital ethics across Africa. Having done these introductions, I think I'll just go ahead and, we'll get the session running. Right. So I think I'll start with Sumaya on the questions. Just a minute. Okay. So I think my first question would be on on the framework, on the legal framework for digital rights in Kenya, senior from Kenya. So what's public interest litigation like in Kenya? Tell us what the legal frameworks are. Tell us how easy or how free it is, to get a litigation matter study when it comes to public interest, especially in relation to tech law. Sumay, over to you.
Thank you, Dolapo. So in terms of public interest litigation generally, the legal framework in Kenya is a lot developed and a lot easy compared to our, if I did maybe a comparative analysis of East Africa, for example, and I'd come at it maybe from the perspective of, say, for example, the subject matter or the cause of action that you would take to court. Given that perhaps at the time our legislations and our constitution, even in 2010, was being made, there was no consideration for tech issues. However, we are able to come or approach the court through certain provisions, basically because our constitution allows, say, if there's a violation of any fundamental right, so you can come at tech issues and file a public interest litigation where any right whatsoever, whether mentioned in the constitution and the Bill of Rights or not. So that's also a very wide net where you can actually approach the court. You can also come at it at the point whereby any provision of law of the constitution, rather, that you find that is violated or is even being threatened with violation. That in itself also is also a very wide scope under which even tech issues can be brought to the Kenyan courts. And then also coming at it from a point of locus, like who is it that can approach the court? Our constitution is actually very, very supportive in the sense that it even allows for unincorporated persons who just claim under a title and they have not been registered in any form, any legal person or form that's known. It actually allows for such people to approach the courts. So there's just a small caveat here when it comes to issues of data protection, because and under our new data protection, the Data Protection Act rather, there's when you're trying to bring claims for relating to violation of your personal data, you have to be a data subject. So that brings it a lot closer. But in the wider net of public interest litigation, then just about anybody, you don't have to have been personally affected. And I say this because if I give like a stark comparison with, say, Tanzania, for example, you find that in Tanzania, you actually have to have suffered. They have an act of parliament, the Bradea Act, which says that you have to have actually suffered personal harm for you to bring a claim in court. So in that sense, then the Kenyan courts are actually very sort of welcoming for persons to be able to approach court. I think recently there's also rather a not so good development that happened in our Supreme Court recently, whereby we found that the Law Society filed a case at the Supreme Court, and they had not participated in the previous courts, the courts of first instance and the Court of Appeal. So the Supreme Court had sort of curbed their powers, even though the essence of such a society would be to defend and engage in public interest litigation. They said that they cannot move forward because they were not parties previously. That's also some sort of derogation from what our constitution intended for public interest litigation to look like. So also in terms of timelines, like the mootness and the ripeness of a case, so our constitution envisions a situation whereby you can file a case if there is an existing violation at the moment, or if you perceive a threat to that particular violation. So to that extent, also you can see that the foundation, the legal landscape and the foundation for public interest litigation in Kenya it's well set, and it's great. So it's also, the courts are also excited about the developing area, like the tech law litigation, for example. It's a fairly new area for our courts. Our judges are obviously impressed also, and also happy to listen to new matters, because at some point it also gets boring if you keep listening to the same issues over and over. So tech law litigation is an upcoming and an emerging issue in which I'm sure the courts are also happy to develop jurisprudence around that area. So in terms of the specific, other than the constitution, there are specific legislations also that encourage the filing of tech law litigations. And I think the main one, it's all more or less centered around violation of fundamental rights. So there's sort of like a human right violation perspective to it to begin with. So we have issues relating to the right to privacy, for instance, where you have personal data has been breached. And then from that gives rise to a legislation, the Data Protection Act, which I had initially mentioned. And the most interesting thing about the Data Protection Act is that, it also came about because of a strategic litigation on tech law that was filed in 2019. So a group of civil society organizations approached court and filed a case on a digital rights identity management system, which was dubbed the Huduma number. So at the time the civil society organizations had approached court, we did not have a Data Protection Act. So one of the key issues in that particular case was that, we don't have data protection framework. Why is the government collecting all this information? How sure are we it's going to be safe? So just typical of the government, right before the judgment, they decided to actually enact the Data Protection Act, which to some extent is a win-win for tech litigation. And I think part of why now we have to sort of move towards approaching and filing more tech litigation cases, so that we can impact such change, and give us more legislations which are helpful towards such issues. So again, the constitution also allows, under the freedom of expression, you can actually bring claims under that. This now comes in issues of social media, comes under Article 33 of the constitution, which allows for freedom of expression. Again, we can also look at it from a perspective of intellectual property rights, because issues of large language models like ChatGPT are bringing up issues which bring about conflict with copyright works. So that's also something that's also it's an opportunity also to litigate on that. Again, we have consumer protection rights also, which is a right under the Constitution of Kenya. You have issues of online sales and e-commerce and digital trade. These are all issues which can be litigated upon. And our constitution doesn't expressly talk about issues to do with tech litigation, all that. But you can see there's so many opportunities for cases to be filed under these provisions. So our constitution is basically timeless, is what I'm trying to say. So yeah, I think those are some of the main issues when it comes to the legal landscape in Kenya. And I said the legal landscape is very great for the purposes of filing tech law litigation. Yeah, over to you.
Thank you so much. I mean, it's really interesting to see that the Kenyan courts are welcoming and ready to develop the jurisprudence on tech law. I mean, as technology continues to proliferate, this is tech law and litigation is one of the many ways for which you can push for better policies and advocacy. So it's really important, and it's really interesting to see that the Kenyan courts are welcoming to such matters. Before we come to you, Marisola, I just want to quickly touch with Arnold. Arnold, my question to you would be, what are some of the tech issues that are more prevalent in the Kenyan landscape? In the coming year or in the coming months, in what areas do you see more litigation matters in terms of tech law springing up?
Thanks, Dolapo. First, just to add on to what Sumaya said. First, I do agree, actually, the tech litigation landscape in Kenya is so friendly and accommodating. First, again, another point to note is that you don't need to be an advocate or a lawyer or an attorney to pursue any tech law issue in Kenya. You can actually do it individually, in person, or even, as Sumaya pointed out, even if you're an unregistered association. Then secondly, the other point worth noting is that the platform also use the criminal justice system to pursue tech law issues. For example, you can participate in proceedings as a victim, so that under the Victims Protection Act, you have that right to even address some of these issues in court. So that in most instances, when it comes to prosecuting tech issues in terms of cybercrime, cybersecurity, and all that, as a victim, remember, you also have that avenue. You can pursue your claim through the criminal justice system and to seek redress. Now, back to your question. Actually, the major thing I see forthcoming, a lot of litigation in Kenya mainly will be on data protection issues and the use of AI tools and systems which incorporate algorithms, machine learning, and all this landscape in general. So that we are looking at also the other aspect we're looking at that will be a platform for more litigation will be in terms of social media accountability by big tech companies. Like, who do we hold accountable? Like, how do you pursue when maybe somebody has posted something, stuff to deal with hate speech, insightful messages on social media and all that. Then again, also going back to the big tech companies themselves, like how do they relate to their customers, to the end users? How do they convey their information? How do they relay their information? How do they share our information and all that? So that I see the tech space largely focusing mainly on platform liability and accountability and issues of data protection, data governance, and the use of algorithms, AI, and machine learning, etc., and all this. Yeah, so it will largely revolve around the relationship between the users and the big tech companies. Yeah, back to you.
I was on mute. Thank you so much, Arnold. Marisola, coming to you. What's it like in Nigeria when in terms of public interest litigation, especially in relation to tech law issues? I know what are the most recent issues or issues you see would spring up in terms of tech litigation in the coming months?
Thank you very much, Dolapo. So, the landscape of public interest litigation is neither here or there, and I'll try to explain it. Being that over time now we have seen that there are more public interest litigation in tech issues that have been coming up on board over the past 5-6 years and so like that, and it has been gradually improving. However, there are still some issues when it comes to when you sue or when you start a matter, tech issue or any other public interest matter. You basically see things like the courts telling you you don't have the standing, you don't have the interest, you don't have sufficient interest actually to litigate on those issues. And that has come up over and over again. We have seen that issue, the issue of sufficient interest of a matter rise from the High Court to the Court of Appeal and down to the Supreme Court. However, because you have to just be strategic in your litigation and the way you go about it, we've seen people embed issues into the fundamental human rights issues, in the fundamental human rights principle. Basically, our constitution in chapter 4 provides for various fundamental human rights. And what people have tried to do, especially digital rights advocates and litigators, is that they try to link up the issue they're trying to litigate into one of the fundamental right issue. The reason being that the fundamental rights rules of court actually provides that you don't need to actually show that you have sufficient interest to actually litigate over the matter. So in that sense, you can actually bring the matter and the issue of local standing can actually die down if you actually bring it under the fundamental human rights enforcement procedure rules. That gives you a correct standing over the matter. Another issue that has also faced tech litigation in Nigeria, the judicial system is not, I won't say they are not totally interested or uninterested. It's also the issue of capacity of those judges to actually litigate on the matter, because we've seen judgments in cases that the judges don't understand the matter. And even when, because these are issues very, very new to the country, very new to the judiciary, then when you try to cite like foreign judgments or any other judgment, even from the African Commission or what have you, the judges just yes, it's persuasive and they're not inclined, some of them are not inclined to look into those judgments, to give a forward-looking judgment in the judicial system. I won't say that is everything is in the negative. I won't say that, but we are gradually moving there. That's just what I would say. In recent times, we have seen issues, bills like the Nigeria Startup Act. We have seen the Nigerian Data Protection. That one was just passed into law recently this year, and those acts are actually going to, I think in the coming months, we're going to see, because it's too actually new to actually like analyze the act versus what it has been able to do. However, we are going to see in coming months that litigation will also spring forth from those issues, because how those acts are supposed to perform with the issues that they're currently facing in terms of startup, in terms of data protection, which has been on the front burner of many litigation issues in Nigeria before the act was actually signed into law, before it was signed into law. So we are going to see a lot of issues coming up in that light in coming months, probably years. And I think in what we're going to actually see is that whether we like it or not, is going to actually shape the legal system in the country. That's what I will say about that. Thank you. Stella, over to you.
I think we've lost her.
Yeah, I just noticed that now.
Ocheng, maybe I can pick it from there.
Yes.
Yes, let me just weigh in on a couple more issues. So in terms of maybe Kenya, for example, I know I mentioned that the Data Protection Act came about because of the previous case on the Huduma, because of the announcement by the Kenyan government of the possibility of rolling out the UPI, which is the new and improved, according to the government, the new and improved digital identity system. There's a possibility of also litigation around that area, because and I say if because the government is yet, as of right now, because the case is still pending at the Court of Appeal, because the government is yet to correct some of the issues they were supposed to correct, save for the issue of enactment of the Data Protection Act. There are still issues which have not been addressed, issues to do with exclusion of certain communities from minority communities from the data, from the digital identity system. So such things will still be issues that are likely also to bring about litigation. I mean, there's still no transparency of the design of this alleged new the digital identity system. So I mean, such things may also possibly bring about litigation and have potential for being challenged in court. Also, I guess as a lawyer now, maybe I can speak and say that the law tech, for example, a lot of there's an increase in the number of systems which are meant to essentially sort of ease out the more traditional and complex way in which the legal system and the legal profession and the business conducts its in the profession the work is conducted. So I think there may be a challenge in the sense that a lot of lawyers who are very territorial and traditional in how they conduct their business may find these apps which assist you in doing affidavits, apps which assist you in doing agreements. These are works which are essentially meant for lawyers, and it may be sort of perceived to be to be a threat to their work, or to be even illegal practice actually. So I think that's also something that can actually be challenged in courts, and has some form of legal basis for being challenged. Again, I think maybe in terms of the digital public infrastructures like Kenya, a lot of government systems, especially because of the new administration, a lot of systems have been converted into e-systems only. So there's a question around what happens. Is there physical services still being issued, or are we entirely using the digital infrastructures? So then there may be an assumption that everybody has access to technology and internet. So is anybody being left out? And I speak of people who have difficulty accessing internet. Can this bring issues of discrimination? Is this something that can be challenged in court? So I guess that's also something that can give rise to litigation at some point. I'm thinking also maybe in terms of there are cases around. I think there's litigation around this area that can still be improved. That there's a case around the refugee camps where humanitarian the role of digital systems in humanitarian aid, for example, around the camps whereby some people have been erroneously entered into these databases, their data has been taken and being used to eventually deny them citizenship. This has been happening to people who live around refugee camps in Kenya. So I don't know, that may also be an issue that could potentially be in the long run lead to litigation. And also it's more or less in the same line, issues of the same data being collected from people living around camps is also being used for surveillance. So that's also to some extent issues that if someone is sort of keen on them, can also be challenged in the courts of Kenya. Yeah, back to you, Ochieng.
Yes, so actually, I do agree with you. In fact, to me, even the Data Protection Act itself creates another potential platform for a lot of litigation, because first it seems, going by the court's interpretation, it now seems that we have a parallel system of litigation under the Data Protection Act. So that because the jurisdiction by the ODPC is in regard to data subjects, and there the courts have said, if you're an individual aggrieved with any such issues of Article 31, right to privacy rights, you go to the ODPC. But on the other hand, if you're a company or an association or an organization, you pursue the said remedies before the court of law. Again, now you mentioned the digitization. In fact, to me, it's more interesting, and it will pose a lot of other grounds for litigation, because now we have the government systems. First, issues to deal with, access to the internet, digital literacy. Now, these are some of the issues that are yet to be settled. Then secondly, even looking at the digitization and the e-system, e-platforms themselves, you see, they pose a lot of administrative challenges, and then issues to deal with, for example, the right to a fair hearing, fair administrative action, discrimination, as you mentioned. So that, for example, if I'm making an application to register even a company, and the system even rejects my name search, you see, I can't even move to the next process. And then the way our systems are designed, there is no appellate mechanism. I cannot pursue that remedy and appeal or challenge the decision as to why is the system rejecting my name, the name I've proposed to register. So I do agree, actually, these are some of the incoming litigations that we are likely to face and to pursue. And then now it will be again us fighting the system again, also in terms of automation. What is the role of an advocate? Yeah, where do we come in as advocates? We just come at the tail end to stamp and rubber stamp a system generated document, all these things, then ethical issues and all that. Yeah, so I do agree that those are some of the issues that you're likely to face in upcoming litigation. Yeah, I see Dolapo. Dolapo is back.
Yes, thank you very much, Arnold and Sumaya, for taking on the conversation. We have a question from the audience, and I think I'll leave Sumaya to answer this. So the question is from Matthew Saisi. It's quite possible that the Hunduma outcry helped, but there's also the political will to curb the digital credit agencies and the havoc they are causing with regards to access to loans. Sumaya, do you quite follow the question, or should I read it out again?
I think I'm just trying to read it out as well. Perhaps you can read it out as I follow.
I think the question is in relation to digital credit agencies, basically digital lenders, and there's been a lot of outcry, especially in countries, Nigeria and Kenya, with regards to the sort of illegitimate way they carry out business, or the infringement on privacy of people and data protection. So I think his question is in relation to what can be done with regards to that.
I think if it's about the issue of I get the perspective on the digital credit agencies, and I think there's been a lot of news around how they conduct their business. They seem almost nearly unregulated, although they still fall within the purview of the Data Protection Act. So although the wheels essentially of getting a lot of people to comply with the Data Protection Act has been a lot slower. For example, big tech included, a lot of institutions are supposed to be registered as either data controllers or data processors, including the lenders themselves, but they're not doing this. So I think there is now that we're discussing litigation, this is also an opportunity for somebody to litigate on an entity which is collecting data and processing data. And you find that sometimes, which I think a lot of people in Kenya actually experience, you find that you are not party to somebody having been taken a loan, but suddenly you're being called, being told your information was given, you're the guarantor of I don't know so and so. You're like, first of all, who is so and so, and when did I consent to being a guarantor? So these are all issues which are within the purview of the Data Protection Act. And now again, the unfortunate bit is that with the Data Protection Act, which I think Ochieng has highlighted, is that you find that there's a mini dispute method being created underneath, so somebody cannot just rush to court. You find that you have to go through the office of the data commissioner. But the point here is that the framework is there under the Data Protection Act. It's just a question of, I think, an initiative to take on at least maybe one of the lenders, perhaps, that should push some sort of change around that issue. Yeah.
Thank you so much, Sumaya. And I think I totally agree with you. A lot of times in different countries, once there's an action against a particular, a particular thing, or for example, take, for instance, digital lending. I think once, two people take initiative to file actions, when their rights have been infringed, it will become a more known thing that people, it'll become easier to take up by other people who can, take examples from the, leaders of this. I know they could just take this initiative and run. So I think once there's one or two cases, there'll be, a lot of other cases. I think, Morisola, coming to you, right? I mean, a while back, you talked about you talked about the courts, you talked about how they are congested, I talked about some of the roadblocks. In your own view and in your experience, would you say it's better to, just take some of these issues to regional courts, or you would say still stick with, national courts, considering the roadblocks and the many obstacles you get to face if you take the national route?
All right, thank you very much, Dolapo. So the thing about it, some of us will say, do we prefer the regional court or the national court? It really depends on the laws or the policies, however stated. In the Nigeria case, if you are an NGO, you can take your matter to for instance, the African Commission. The African Commission can stay litigator on your matter. However, for the African Commission, some of the criteria are that you have to exhaust domestic remedy, or domestic remedy has to be impossible to exhaust. Then you can now bring your matter. You can't, even for the African Commission, you can skip that domestic remedy. So you have to have recourse to the national to the national courts. And even for the African courts, we have the African Commission and the African court at the African level. The African courts, Nigerians, NGOs, or individuals can't even access the African courts because Nigeria has not actually accepted the jurisdiction of the African court. So that is like an impossibility for us. So except our matter goes to the African Commission and the African Commission takes it to the African court, we have no recourse on that front at all. And even if you look at when I was preparing for, and when I was looking at the amount of countries, for instance, in Africa that have accepted the jurisdiction of the African court, it's just very few. We just have 8 of them. But so many countries have actually ratified the protocol that actually established the African court. So it's really dicey, and we can also jump the gun. I've told you that the instances where you can go straight to the African Commission or probably the international court is probably if you had exhausted domestic remedy, or if domestic remedy is impossible. So there are instances where domestic remedy is impossible. For instance, I think there was a time Media Rights Agenda was litigating on internet shutdown against numerous African countries, Nigeria included, and we had to show that, okay, it's impossible to exhaust domestic remedy on that front because it's not just Nigeria that the issue was in. It's also some other 26 other countries that also had the same issue, and it's going to be too expensive and too impossible to actually exhaust domestic remedy in those countries before we got to the African Commission. So that was the reason why we're bringing it. So in that instance, yes, you can bring it, something like that, or something else. You can actually take your case to the African Commission and they will hear it. Also, you can also jump in terms of regional courts. For the ECOWAS case, you can just go straight to the ECOWAS court on the West African level. You can go straight to the Africa and to the ECOWAS court as an individual, NGO, what have you, and you don't actually have limitation to that front. Most people prefer in tech litigation, they prefer just going to the ECOWAS courts, despite the fact that, yes, the ECOWAS decision is binding on Nigeria as a member of the ECOWAS, but we have also seen where in number of cases, Nigeria does not even budge. Nigeria does not even accept the judgment or do anything about the judgment. The judgment is just left out there. But I think that if we continue on this front, like going to the ECOWAS court, the African Commission when need be, and even litigating at the national courts, there's a number of challenges. But even if we keep pushing, sooner or later we'll actually, because over the years, we have seen that people have been pushing, and despite the fact that there are a number of challenges, judgments have been coming out, some in our favor, some not in our favor, but we try again and what have you. Thank you. Dolapo, over to you, please.
so much, Marisola. Arnold, I think I'll just let you just add to or give us the perspective in Kenya with regards to the question asked Marisola on regional or national courts.
Thank you, Delapo. In fact, I do agree. I take a different view. For me, I prefer national courts, going by the Kenyan experience, because at the end of it all, if you look at most of the regional courts, they have that fallback, that clawback clause, which says you must exhaust the local remedies or demonstrate that the local remedy is not available. Then again, another limitation, for example, if you look at the East African Court of Justice, as we speak at the moment, the protocol on the jurisdiction of the court to hear and determine violations of human rights is yet to be enacted, so that it has been, I think for political reasons, the member states have been reluctant to grant the court that exclusive jurisdiction to determine human rights issues. But as human rights practitioners, we've always used the route for under Article 6D and 7.2, which speak of good governance and the rule of law, so that when you talk of the rule of law, any violation, you just throw it in there and leave it to the court's interpretation. Most of the time we use it, we interpret it to suit our case and say, that's a violation of the rule of law. So that's how we end up under at the East African Court of Justice. Now, the good thing with the East African Court of Justice, they don't have that requirement for exhaustion of the local remedies. Again, we must remember that for most of the regional litigation, it is not appellate litigation or appellate jurisdiction. You have to go there on original claims most of the time. Yeah. Then secondly, I do agree with Morisola, especially looking at the ECOWAS Court. In fact, I remember last week, I think it was last week, the ECOWAS Court and the African Court of Justice just signed an MOU on collaboration and sharing ideas and all that, yeah, which is a positive sign. Although now the downside with, for example, the African Court, now individuals don't have that right of access to that court, so that even organization, not all organization, not unless you've been granted the observer status, and then not unless the African Commission on Human Rights and People's Rights refers a matter directly for the court's intervention or advisory opinion. Now, going back to the ECOWAS Court, actually, it gives a wider latitude. Remember, first, the other limitation is you have to be a member state, yeah, for the ECOWAS community. Then it gives the latitude and locus even to individuals and even organization. And given the past experience, in fact, this court has been more keen on addressing tech law challenges. We've seen in the recent past in the case of Amnesty Togo versus Togo, actually, which concerned the internet shutdown, whereby the court, in fact, went on and pronounced itself on the legality of the shutdown and held that, in fact, access to the internet is a fundamental right, so that the shutdown by the government was a violation and a breach of the African Charter, among other instruments. So in general, tech litigation, either at the national or regional level, will largely be pegged on the constituting statute of the regional platform, regional court. And then secondly, it will depend also on the circumstances of the country, national involved. So all in all, they're interlinked. But for me, if you are to go the Kenyan way, although under the East African Court of Justice, you can pursue parallel proceedings on tech law, because you can go under, for example, Article 34 of the EAC Treaty of the Constitution of the Court, which says if parties are willing, they can make a reference to the national court to refer a matter for a matter of interpretation of the EAC Treaty to be referred to the East African Court of Justice. And the interpretation given by the EACJ will be binding on the court, and it is superior to any other interpretation to be given by the national court. So that at the East African region, it is more interlinked. You can choose to divorce them or you can choose to marry them together, but at the end of it all, they can still work out for you, yes.
Thank you so much, Arnold. Sumaya, coming to you. When there are tech law issues or tech law matters, in your view and in your experience, do you think that litigation is the best route to go? Or you believe there are sort of other opportunities or easier routes to go through? And also, what are the other options in terms of resolving conflicts or resolving issues that relate more to tech law matters.
Thank you, Dolapo. So in terms of the cause, because this is the cause with the COURSE, the cause to take, the other than public interest litigation, first of all, public interest litigation in itself would not necessarily be the solution. In itself, they should be complementary mechanisms that you work around. For example, if you intend to take on a case on tech law and all you do is, file your case at the courts and wait to be heard, that in itself may not give you what you're looking for. Even the manner in which the court will treat your case will depend on these mechanisms that you employ. So for example, the litigation route, you can also have, do advocacy as a complementary mechanism, and advocacy is a very huge part of litigation in itself. Research, the kind of research you bring before the court, the experts that you present to the court, that would also in itself, influence the decision and the overall route that your case is likely to take. Now, aside from the court process itself, you can also explore ADR as an option. But now the means to balance between ADR and litigation would be pegged on a number of issues. For instance, if you're looking to sort of embarrass tech giants, you will not be using ADR because that may not in itself serve any purpose, because they will simply, and ADR is expensive, so for them it's a walk in the park, and it may be difficult for the parties bringing the cases. So I think you choose your case based on what the outcome that you're looking. I mean, you choose your route based on the outcome that you intend to get. So if you want to do social and policy change, ADR may not serve you to that extent. If all you want is to get reparations for, say, for example, I think Ocheng had mentioned a case they were doing on content moderation for content moderators. If all you want is, privately get compensation for this, the content moderators, then ADR may be a good route. So I think these are the number of issues that you may have to consider as you're taking, as you decide which route you're trying to take. Yeah.
Thank you so much, Sumaya. Anna, coming to you. I think if this is going to be on, on legal frameworks now, what opportunities or what support do you think the Malabo Convention offers to on enhancing tech law matters or tech law litigation? Do you think it sort of promotes it, or it sort of gives it like a gives it like a push in terms of promotion and advocacy?
Yeah, I think first, let me say the Malabo Convention might be coming into force anytime from now. I was expecting the big announcement actually last week, because the last state actually ratified it, I think, later last month. Yeah, but I'm hoping very soon it will be in force. Now, actually, the Malabo Convention, I'd say it's more of a pudding of laws and ideas touching on data protection, cybersecurity, personal data concerns, and everything. It's a mixed bag of everything. Because if you look at national laws, for example, countries have enacted specific legislation, for example, to deal with cybersecurity and cyber crimes. Then when it comes to data protection, countries again have enacted specific legislation, like what Nigeria recently did, for a legislation that has been hanging for a very, very long time, but I hear it's very comprehensive. So I think even the time factor in itself was a blessing in disguise, so that they got to address most of the issues. Yeah. So in terms of even the Malabo Convention, I think it is mixed up. It has a lot in one package, but that notwithstanding, again, the ideas are good, the intentions are good, but now it becomes problematic because, for example, most of the provisions are not substantive. They just, they have the clawback clause which says, it is upon the state parties to enact this and this to address this, so that it is not as express as you will expect for international conventions or regional conventions, which says if somebody is entitled to the right to equality, it is entitled as it's stipulated in the convention itself. But if you look at most of the provisions in the Malabo Convention, it is actually left to the states It just gives the parameters. On data protection issues, it has done, I'll say, well, because even most of the national legislation on data protection have largely borrowed from it, because it captures principles like consent, prior knowledge, authorization, protection, pseudonymization, all these things. Some of these provisions are explicit in the convention. Then again, the other aspect I feel is not well addressed in the Malabo Convention is in terms of even dispute resolution, because I would have expected like to have an organ to deal just with specific disputes or tech law disputes, or because although the mandate there is given to the states and told you can put in place measures to deal with all this cybersecurity, etc. Now, the other good thing about the convention is it brings out the collaborative aspects and obligation, so that it calls upon states to first collaborate among themselves, then again at the national levels, collaborate with the different players, the police, the judiciary, the various government departments, and all the whole chain, the whole web of tech law interconnections. Yeah. So in terms of opportunities, it is, I wouldn't say it gives 100% opportunities. I'll stick at 65%, but the back falls with the states involved. Now, again, the problem with that is now it falls back down to the will of the states, political will. Again, my other biggest fear is this convention has taken a very long time for states to ratify. Even as we speak, it's only a few states, yeah? So that if that is just at the ratification stage, now the question is, are these states willing to implement it or give it the full attention and all that? Because ratification has taken a very long time, considering tech issues, cybercrime, cybersecurity. These are things that legislation always plays catch up to, so that even as we speak now, I feel there is need now again to relook and rethink some of the provisions. So we just adopt to whatever has been happening for the last 12 or so months. Yeah. So it's a matter of playing catch up with tech. That is the law. Every time the law has to play catch up and all that. Yeah. Back to you.
Thank you so much, Arnold. I love the fact that you mentioned the issue of implementation, because a lot of times that could really just, post itself as a huge roadblock. Rosella, coming to you, when Sumaya was speaking, she mentioned how, when you're handling or dealing with tech matters, you sort of have to, all the actions you take are sort of, it should be holistic and complementary, right? There's the angle of research, there's the angle of the litigation, there's advocacy. So in terms of taking all this into consideration, right, what would you say is the place of donor funding? And, some of these issues or some handling these matters can be quite, capital intensive, right? So what would you say is the role of donor funding in helping or promoting tech litigation, or just promoting tech litigation?
Okay, thank you very much, Delapo. So the donor funding, we know that coming from somebody that I've worked in the NGO space for a while now, donor funding is actually very important to litigation. We all know that litigation is expensive and it's time consuming, and you can't do it without money, because it just keeps, new things just keep coming up, and you can't actually ascertain the amount of years you actually spend in courts because of so many other issues. However, these are the issues. Donor funding becomes important, especially if the cases are that of a public interest nature, because you might not easily get like funds from organizations, and you know that most of the time cases of public interest nature are basically done by people that works, human rights activists, NGO, human rights defenders, all. However, there's also a need to also be careful with donor funding, because you have to also know that probably you have donor funding that is not just we all know that it's not just every fund you should get in terms of your work and your activities as an NGO or as a rights activist in general. Donor funding can also be very limiting in terms of if you go and get a donor fund that actually restricts you in the way you should go, and not actually just wants to fund your activities and how you want to go about it. It can be very, very, very limiting. Also, donor fund, because we know that litigation is not actually something that you can put a cap on that, okay, yes, you're going to go 2 years is going to finish, 10 years is going to finish. You also do not want to tell your donor that, oh, in 2 years we'll be done. You have to also keep, because whenever we ask for funds, while I was working with an NGO for litigation, we'll tell them that we cannot ascertain when the litigation will end, but this is the amount, or this is how we want to run it, so that you can have enough room to be able to accommodate litigation process and whatever litigation brings your way. So I think donor funding is essentially important in terms of litigation, especially for public interest and tech litigation. But I think, yes, we still have to tread softly in terms of where the funding is coming from and how the donor intends you to use the funds is where you have to also be careful of. Samira earlier mentioned about, in terms of litigation, it's not just going to court, filing a case and waiting to be heard. There's also a room for advocacy. There's also a room for media outcry and the likes. There are also rooms for so many other things. So it's not just going to court. The court can just determine your case, whatever. But when you put other tools in place for your case, I think that's where you get a strengthening leg. So all those things is also what you have to consider in terms of requesting for funds from a donor, and probably organizing or structuring the way of using those funds for public interest or tech litigation at large. Thank you.
Thank you so much, Marisola. Interesting view. I think my next question would be for Sumaya. In terms of social media accountability, and responsibility, there's sometimes when, or a lot of times when a wrong is being done to someone, there's really the issue of who to hold accountable. How do you go about this? What's the next step, what to do? And a lot of times people, because of all the confusion and there's so many what ifs, whys and hows, a lot of times people just abandon these issues and then they just overlook these things. But for me, I think my question to you would be in terms of the dispute mechanism for a lot of this big tech, right? What's your view on them? Do you think how embracing and how enabling do you think they are? And in cases where you feel like they are not so helpful, do you think that this is done intentionally?
Thank you, Dolapo. So in terms of I think the intention, the big tech would never be keen on restricting themselves. So this is something we need to call on to them to restrict. So the design of basically maybe the AI of how some of these social media platforms work, unless we question them, they will never they don't find the need to, basically nobody's holding them responsible. And the manner in which some of them operate in jurisdictions like, say, Kenya, for example, is that they're not really registered, like how you find your next door company having been registered and can be held responsible by somebody. They're not registered. They have some funny agreements that they enter into that allow them to operate off the normal procedure. Like I had initially mentioned, how some of them are not even registered as data controllers, and they control data of people within the jurisdiction of Kenya. So I think some of these issues would come down to you have to actually you can have although the internal mechanism may not necessarily be as effective, given the fact that they're not more so registered or controlled within certain jurisdictions, then it's fine. You find that then you have to go to court to actually call on some of these issues, like, for example, transparency and bias in the way in which their algorithms work, how they operate, how they collect the data and are not held responsible for it. So I think at the end of it all, when it comes down to the dispute resolution mechanism, for as long as they are not really within or controlled or registered within the jurisdictions, then you have to call on them to actually, like what the Facebook, the Meta case, for example, has done. It has called on Facebook to come and answer to questions in the Kenyan courts as to what they have been doing, because they've not been registered in Kenya. So I think that's the place that dispute resolution has to work, and how you call on them for accountability and responsibility over their social media platforms.
Thank you so much, Mayor. Marcella, I'd like you to also give your view on, the disputes techniques or the disputes frameworks by this big tech?
Thank you, Dolapo. So I think for big techs, we have seen over time that in terms of dispute resolution, big tech are more, firstly, I think what they're more concerned about is profits before human rights or any other thing. However, they've been pushed over time to actually ensure that human rights is enforced on their platforms. And I think, like Sumara has rightly said, is that most of the times they are not regulated in any sense. And you can, on one hand, say that being free will actually enable like more free speech, free expression, on the other hand. On the other hand, if not, I think it will just be they're basic because they're private companies, and what they basically are after is just is profit. I think that's first before any other thing. So in terms of their responsibility and procedures, I think what can happen is that if they are regulated to some extent, I think it can help enhance dispute resolutions amongst probably the government, country, or even users on their platform. I think it can also help to help them so that they can also shape it in the sense that it's not just about them and what they want their platform to look like, but it's also about what the users of the platform are going to, it's also about not endangering the users of those platforms and the like. So I think regulation, yes, but not over-regulation, as we'll say. And I think that in terms of dispute resolution, they can also use other methods aside and improve on whatever they're actually doing at the moment.
Thank you so much, Marisola. Arnold, coming to you. What recommendations, still on the same issue of, accountability and transparency by these companies, what sort of recommendations would you make to their dispute resolution mechanisms? Anna, did you hear me?
Dolapo, perhaps I can join in on that particular question. So I think maybe one key recommendation that these social media platforms need to adhere to would be the change in the algorithms. For example, say Facebook, for instance, has been accused severally of having, fanning the violence that has been going on in several places like Ethiopia, like has been brought before the Kenyan courts. So I think a change in algorithms for these social media platforms, and it's something that has not been called upon them, but now that they're being subjected to having to go through the court process, it's something that is now known because it wasn't known as such. So I think a change in how the systems work would be very integral for accountability on their part. Yeah.
Yeah, just
Thank you.
Sorry about that. I'm back. Yes,
Okay.
just to add on what my colleagues have said. First, I strongly believe, I have a feeling that the failure to have strong dispute resolution mechanisms by these big tech platforms is not by accident. It's simply by design, because to me, it's more of a case of a man being a judge in his own cause. Because you're telling me to have a dispute resolution mechanism to find me and interrogate my conduct and sanction me for my conduct. Yeah. See, for me, that is by human nature, definitely. They'll be reluctant to have such strong dispute resolution mechanisms within the organizations. Then again, in terms of now the other dilemma that comes in terms of even donor funding, you see, you'll need donor funding. It is these same big tech companies that are the ones funding, that we are going to them seeking for most of these donations and funds to strengthen all our activities. But in terms of recommendation, that's where now strategic litigation comes in, because when you now go for strategic litigation, what is it that you really want to achieve? And then ask yourself, does it align to the causes of whatever donor, or is it in a genuine public interest? Or is it a money minting scheme that you just up to do? Yeah. So that in terms of, for example, if you take up a strategic litigation for responsible tech, what sort of remedies do you want to achieve at the end of the litigation? So that for me, for example, if I undertake a strategic litigation for responsible tech, I'll seek some of the remedial measures from the court. In Kenya, we have what they refer to as the structural interdicts, whereby the court issues orders which the court itself can supervise or direct the party to comply with certain orders, and in what manner of orders are to be done. Because we've seen it happen. We've seen in terms of, for example, enforcement of socioeconomic rights, where the state asks the government, go out there, put a policy in place just to prevent unlawful eviction of persons, ensure there is public participation, then come back to this court after 6 months and give a report of what measures we put in place. So that in terms of strategic tech litigation, I would adopt such an approach, so that, for example, if I'm seeking prayers and remedies, I'll be asking the court maybe to compel an order of mandamus, maybe compel a big tech company first to have a specialized tribunal or department specifically to deal with disputes. Then secondly, maybe have engage external parties. I know it's a tall order, but this is the role of a strategic litigation. We have to look at practical solutions, not just to throw orders to court, because we will go to court, we will seek orders and say, yes, there was a violation of the right to privacy. Then what next after that? Because if it's about big tech, they'll know we will get away with such an order, because we'll simply be told, pay compensation or damages and the cost of the proceedings to the tune of maybe $500,000. They will sort that and move on to the next one and continue making their profits. Yeah, but we need long-term strategies and goals, and that's when now strategic litigation comes in. So that in terms of structural interdicts, then secondly, we can have, now this boils down to the regional strength. We can now formulate specialized bodies and tribunal. We've seen the World Intellectual Property Organization. We've had such tribunals just specifically to deal with international violations of intellectual rights and all this. So why can't we emulate such procedures? Why can't we have such mechanisms? Then again, more importantly, in terms of capacity building and training and working as joint forces, so that we can have, for example, in this case, ITPA and TechHive and Ikigai working jointly, yeah, and collaborating and appearing together, maybe in court proceedings at the regional level. Yeah, we are speaking on behalf of the East African region, and you guys are speaking on behalf of the West African region, and we are pushing for this or these certain aspects. Yeah, and then so it's more of the strategy adopted, and then also now bringing the donors on board and telling them we are doing this, and we want also you as with that influential authority. You know, they can also push, because the way I mentioned it, with tech law and tech law litigation, it's more about the law playing catch up with tech, so that it's more like we need to move together. We need to look at the best ways and strategy how to adapt and move together jointly, not just litigating over litigating. Because by the time we're finishing one aspect of litigation on a tech issue, now technology has grown, it has advanced. So now again, you're back to square one now, another approach. Yeah. So let me leave it at that. Yeah.
Thank you so much, Arnold. I love the fact that you mentioned in some breadth self-regulation, and also the really interesting and important place of the courts and policy as well. You know, in addressing these issues holistically, not even just one after the other. We have a question from the audience, but before that, I'll just come to you, Morisola, and also thank you to our audience for staying with us to this moment. Please send in your questions or your comments, and we'll be happy to, you know, bring it to the panelists for you. In terms of capacity building, how equipped, and this is for Morisola now, in terms of capacity building, how equipped do you think, you know, our courts are for handling such issues? And I'll give a really practical example. Sometime last year, Ikigai filed an action in court against the law enforcement agency. So the core of the matter was that the law enforcement agency had developed an app sort of, you know, and we had a lot of concerns about the app. You know, there was no privacy notice for an app that was built by the law enforcement agency to promote, you know, to help them with their with your duty, the app had embedded in it advertisement trackers. I know all sort of things, right? And we submitted empirical evidence to the court about this, right? And sometime last week we haven't seen the judgment, but the summary of the judgment is that the matter was dismissed, right? And these are some of the, and for a matter where we submitted empirical evidence to privacy right concerns, and infringements, there was no action by the court to say, oh, we're mandating the law enforcement to do this or do that, right? And this, brings me back to my question: how equipped do you think our courts, are for handling, emerging tech issues or data protection matters? Do you think there needs to be more capacity building or training? And if yes, how do we go about these things?
Thank you, Dolapo. So basically, I think in the Nigerian setting, I don't think the courts are well equipped to handle this tech litigation matters. I'm not, when you said the summary of the judgment, I was not surprised, because I've had issues like that over time in tech litigation and other kind of litigation as well, where the courts, the interpretation of the court does not even actually match what the law or what the issue is all about. And you are wondering what was the mindset of the judge while drafting such a judgment. I think it's lack of capacity. Most of our courts in this country, in Nigeria, are actually more of a tradition kind of courts. Sort of, they are still embedded or interwoven in their tradition and what have you. And you only have a very few progressive judges amongst them who can say that, okay, this is the future and these are the issues, and probably judges that understand that you have to decide these issues, not judges that will want to be playing catch up when everything has gone bad. And just a very few of them. I think the issue, what we can do concerning that is that we have to just build capacity of judges. Again, while working with the NGO I worked with, capacity of judges kept coming up over time because we saw the need to actually build capacity of judges, as the lack of knowledge in these areas, these novel areas, actually have dented the cases in more ways than one. But building capacity of judges has been seen to be expensive. And in terms of what are the structures for you to bring a judge down and everything, there's so much to do in terms of that building capacity. You have to put judges and justices in one space. So in terms of funding, you now you have to see the amount of funding it's going to take, bringing them, their orderly and the others. I think what we can do is basically to go to the forums, to go to the umbrella guiding the judges and everything. I'm trying to remember that of Nigeria now, but I can't. But they have like an association, they have all this forum and everything. And from year in, year out, they have like probably meetings and the likes. And you can go under that umbrella to actually build their capacity in certain matters. As an expert, you can collaborate with, the National Judicial Council is what I was actually looking for. The National Judicial Council, you can collaborate with them in order to build capacity in certain areas. And I think that can actually work, even if I don't know to what extent and how fast it can actually work concerning the judges. But I think over time, if it's something that we do on a very consistent basis, I think that would actually in time actually make an impact. And even if it takes longer than MPCH, and I think over time it will work. And again, if you see that most of these older judges are also getting to the point of retirement, so they go, new ones will come, and if we just keep doing what we do with consistency, I think collaborating with these judicial bodies, we will actually make an impact. And that's all. Thank you.
Thank you so much, Sumaya. Sumaya and Arnold, I just want you to quickly weigh in on this. Maybe Sumaya first, and then Arnold can go after.
Thank you, Delapo. So in terms of capacity, I think first of all, I'll just start by saying that at least in the Kenyan context, I'd say that judges are first and foremost lawyers. They are nothing else. They did not study anything else. Their profession is law. That's it. So I think starting off, you're expecting somebody whose profession is just the law to understand a number of issues. At one point family issues, at one point children, at one point tech, and now you're bringing to them issues which even to the ordinary person, it's a little bit more difficult to understand. So I think training for judges is a very crucial matter. which brings in again the issue of donor funding. And I'd say that, donor funding is just a double-edged sword, it can serve you and it can swipe you off if in such a case, for example. So the same funding that is needed for, to assist you in getting through all the route through the cases is the same one which may be used against you also in terms of how the judges may be trained. So I think at the end of it all, as of right now, I'd say the judges, the courts and the judges are not per se well equipped to deal with the cases and to deal with the emerging tech issues. However, there is still opportunity for them to be trained, and I think funding comes in at this point. And then a very small issue, I think, but it's relevant when you're talking about judiciary. And I think also sometimes it's the kind, although we say that it's a decision of the court, it's always a decision of a specific judge. For example, at the Kenyan court, one judge ordinarily sits alone at a high court, and that's a very powerful position. So I'd say if you have not lazy, but if you have a corrupt judge, if you have a lazy judge, that may somewhat impact your case. So I think at the end of it all, it's you look at it from the wider angle, not just for the courts which you're before, but in the long run, in terms of all the tech issues that we had raised that are possibly going to be litigated, just training judges in all throughout the country, for example, and trying to build on emerging tech issues as something that is an ordinary norm, just like any other, the way we have divisions on succession and what have you, yeah? So yeah, that's it on my part.
Thank you so much, Sumaya. Arnold, anything from you?
Yes. Just to add, again, now, the way I mentioned, the only dilemma with tech and law is that the law has to play catch up. So that even now, as we speak in this forum, most of us in the syllabus at the law schools and all, we did not have tech. It was not as deep as what we are discussing now. But then we did not have the Malabo Convention and all these things, all these issues addressed. So that again, now it calls for, first of all, rethinking the syllabus. And then the syllabus also has to play catch up with tech as we proceed. Yeah. Then secondly, even in terms of training is so important. Now, the other problem is the way the system is designed. For example, in this platform, most of us are lawyers, advocates, and students. I'm sure we don't have any judicial officers or even government officials that we would have expected, probably. Although now the bureaucracies and how the systems work, they have to, for such sessions, they just have to seek certain bureaucratic approvals, written authorization, and all that. Yeah, so that again, it's not just about training, it's about how do we rethink, how do we incorporate such trainings. Then the other challenge, also systematic challenge, I call it, is in terms of in the tech space, for example, we are somehow we're working in silos, in a cocoon. So that today we go for the Internet Governance Conference, it is the same group of people. We go for another conference for Drift, for example. We meet the same clique of people so that we talk about our own tech issues, tech stuff, then make our own recommendation, then say, okay, see you again in Japan in October for the IGF 2023. Yeah, so it's more about reaching out and then just trying to navigate and going through the system. Yeah. Then the other issue actually, which Sumaya has also mentioned, is in terms of having specialized court, because we're coming from that traditional school whereby we have specialized courts just dealing with employment, commercial matters, environment and land matters. But ideally, we are not playing catch up with technology, so that at this point, it is so important that we also have a specialized division just to deal with tech law, tech, emerging technologies and all that, so that we want to create now another pool of expertise. Then finally, and more importantly, closely related with training, is the role that we play, especially as Tech Hive, Ikigai, and IDET, in terms of participating in proceedings as either interested party or an amicus, because now we bring in that aspect, that lacuna, because now we are coming in as a neutral party with the expertise. We are presenting to court, because most of the time in this tech law litigation, if I'm suing, for example, those big tech companies, I'll just do my research based on liability of this tech company. I'll just look for authorities and case law and everything just to support my case. Yeah. But if you come now looking at the angle from an amicus position, you're bringing in the expertise. You're telling the court that in country A, the court held this on these particular issues. In country B, the court held this. In this particular circumstances, this regional court held this and this, so that even the amicus themselves play a good contributory role in shaping the jurisprudence and assisting the court in developing all this. The other challenge with this also I've seen in the recent past is now the courts have imposed this restriction even on joinder, because in some instances, a party will be denied the opportunity to participate in the proceedings without, once they make the application. It is not also a strict rule, or it is not automatic that once you apply to be joined as amicus, you'll automatically be allowed to participate in the proceedings. So that, again, those are some of the capacity challenges that you're likely to face, so that it is on both sides, on the flip of the coin. Yeah. So all in all, I strongly believe there is room to do a lot, so that we can really maximize on training, joint webinars, joint workshop, and just having that a conversation between the judges, judicial officers, litigants, and even as advocates and the tech group. The problem again here is today we are here speaking about strategic tech litigation, but we are speaking again amongst ourselves of the legal cocoon. Yeah, it will be interesting also to have the techies in the room, so that they can also get their perspective, because they also have issues which will most of the time we interact with in terms of copyright, intellectual property and all, but there is more to that, to the techies also, which we can have in the conversation. Yeah.
Thank you so much, Arnold. I'll go to the audience now. We have one question from the audience, and it's from Chris Kemburi. I hope I got that right. So the question is, can tech complaints or data complaints that are made before the law is set by the government be taken care of after the law has been implemented? And yes or no, and why?
Okay, let me start. Let me take that. Yeah, thank you, Grace, for that question. First, I'll say the first principle that kicks in is that on non-retroactivity of legislation, so that you cannot pass legislation for it to be implemented in regard to past occurrences. The law does not work in a retrospective way. But secondly, we also have exceptions to that rule, so that now it depends with the nature of the violation. Is it a fresh violation, or is it a continuing violation? So that when I say continuing, I mean the violation started way before the act was enacted, and even after the enactment of the act, the violation still continues. So that by that, you see, you are not barred by the doctrine of non-retroactivity. You can still pursue a claim, but commencing from the date the act was enacted. And finally, again, if you look at, there is always a better approach when dealing with aspects of non-retroactivity. For example, I always use, as a human rights practitioner, you take the approach, for example, let's say your particular constitution of a country did not provide or recognize certain rights before the enactment. But before the enactment of that particular statute or constitution, these were rights recognized under international law. So that instead, you can argue using the angle, you can pursue the angle and claim a violation of the international law that then existed before your enactment came into force. So that if you speak of the right maybe to access information, if it was not, for example, recognized under your current statute, but it was by then recognized under international law, you can still sustain that claim under international law and claim a continuing violation as such. Yeah.
Thank you so much. Any of the other panelists, Sumaya, Marcella, want to weigh in on what Arnold said on the question by Grace?
Okay. So thank you, Dolapo. So I think basically, Arnold has actually said the correct position. You cannot sue somebody under a law that just came in for a past offense. Under the Nigerian context, at least that's the position. You cannot, because when the offense was committed, there was no crime. And but if there's a continuous offense in that light, or there's a continuous breach, then yes, you can now bring it when the law comes into existence. And probably the previous one can now form part of the facts of the case. But really, you can't actually judge a case based on a crime that a crime that was committed or an offense that was committed when there was no law. So I really agree with Anna. Thank you.
Thank you so much, Marisola. Thank you so much to our panelists. It's really been a great time, and I'm sure the audience and attendees have learned a lot from what has been shared and the insights that you have given to us. And we hope that this webinar is sort of the foundation or ground for a lot more advocacy and litigation matters in relation to tech law. I'd say a big thank you to our panelists, Marisola, Sumaya, Arnold, for being here today. I'll just hand over to Sumaya to give round up.
Hi, Dolapo. This has been a really great call. I think from my end, it's just been like a lot of learning and a lot of reflection, especially looking at how things are the same in both our countries, but also slightly different. I just would like to thank everyone who's joined our webinar today. We had over 100 attendees joining, so that's really awesome. It shows that we have a lot of interest in regards to strategic tech litigation. And so we'll definitely, as Ideate and Ikigai and Tech Hive Advisory, look into having more of such sessions. Maybe we can now have different sessions where we discuss reflections on our, on our past cases in terms of strategic tech litigation. I'd also just like to thank the panelists, Sumaya, Morisola, and Arnold, who've done a really amazing job. And for you for also moderating, giving you also your flowers. So just like thank everyone for making it here, for engaging, for asking questions. I'm not sure if there are more questions from the audience. I saw there was a hand up at some point. So we'll also take all of them. Please follow our social media accounts. We're going to share our Twitters for all the 3 organizations that are hosting today. And follow us, and we can engage more there in case there's certain issues you'd like us to also host on. We're ready to take that up. But I think for me, it's just looking at where we are in both our countries with strategic litigation, and of course taking the pointers from our panelists on how to improve litigation in our countries. So I think that's all from me. Thank you, Dolapo.
Thank you very much, Maya. So we had a hand up from Kelvin Opera. I hope I didn't murder that name, but you could please proceed to speak. Thank you. If he's still here. Kelvin, please go ahead. Well, while Kevin is trying to, get speak, I'll just read the comments and the question we have. Well, we have one more question. So Susan Otieno says, great session, not able to comment in the chat, so posting here. So that's just a comment from her. We have another question from Grace Cambury. She says that there was a data theft at a supermarket here in Kenya. Navas, could you guys please comment on that? Sumaya, Arnold want to weigh in?
Grace, thank you for that. Okay, although I saw it circulating online, we saw different communication by the parties, so that out of caution, I think the matter is before the Office of the Data Protection Commissioner, so that the lesser we say about it, the better for now. But we can actually wait for the outcome of the Data Protection Office of the ODPC, so that we can now get a lot of material out of it. You can even have a webinar just to discuss the issue of data protection, how when the company or an organization loses personal data and all that, then the duty and responsibility to report a breach and all those issues. Yeah, so for now, that's the best I can do about it. Yeah, but we can discuss it once we get a decision from the ODPC.
Okay. Thank you very much. Arnold, thank you again to all our panelists. It's been a really great session. And, we hope to host you sometime in the future on, more interesting tech litigation that, might have come up. Thank you once again. Have a great day, everyone.
Bye. Thank you.
Thank
Bye,
you.
bye.
Bye.